next session is hosted by MCIA. The topic of the session will be the founder's dilemma. Should all startup disputes be fought or forgotten? The session is moderated by Mohit Abraham. The speakers include Dhyan Chinnappa, Nandakumar, Nishanth Kadur, Poornima Hatti, and Shilpa Shah. I kindly request the speakers to please come on stage. Thank you.
Good evening, everyone, and thank you to the organizers for having all of us here. We're looking forward to what will hopefully be an interesting session on the founder's dilemma, when to sue, when not to sue, those kind of issues. We have an amazing panel of some of the leading disputes arbitration experts in the country, so much so that one of our panelists is actually still in court, but is on the way, so that really shows the chops that we have. So we are very excited about this session. Just to lay out a bit of context, so I've worked closely with startups and founders for the last 10 years or so. In my experience, it's one of the hardest professional journeys one could undertake. About 25% of startups only will end up even returning capital to the investors. So that's astonishing. Think about it, 75% of startups are not even going to return capital to the investors, or for the founders for that matter. Only about 1% of startups are actually going to be unicorns, that is billion-dollar companies. It's a super, super hard job, professional journey to actually set up a successful startup. I would say you have to actually be a little crazy to even undertake that journey. But when they do it, it's obviously very fulfilling. There are a lot of constraints that founders have. Money obviously is a big one. Reputations are still being built, so they are very fragile. Allocation of just resources, and the single most important resource is actually one of time. So when you think of all these things, founders really have to make critical decisions every day. How much money can I spend on this product or this engineer or this particular issue? And in that steps in legal issues and disputes. So whether to sue, whether to settle, whether to send a legal notice, whether to go for mediation or arbitration becomes a very, very challenging topic for startups. So that's the context. We are going to leverage on the expertise of the panel, discuss a few different topics and themes. And I thought we can start with Dhyan. So Dhyan, again, founders have to make money go the longest way. You are a senior counsel. No panelist here is going to be cheap. Their legal advice is going to be very expensive. Of course, I'm sure they do pro bono work and so. But it is a huge decision point for founders to decide, should I sue, should I not sue? At a very high level, if you had to think of a framework on when to approach court or when to really pull that trigger in terms of activating a dispute, or different layers in terms of settling, making a legal threat, any one of those concepts, just at a framework thinking level, how would you advise young startups and founders to think of that?
Thank you, Mohit. It's a pleasure to be here. Like the Warren Buffett's 2 rules for his CEOs, I have 2 rules for promoters. Rule number 1, do not litigate. Rule number 2, do not forget rule number 1. That, of course, sounds a little distressing for a litigating lawyer to say. But the point really is this. Money is scarce, time, resources, all of which are early startup founders are hard-pressed for. So when you decide to litigate, you need to choose your cases. You need to choose when you must fight. I think long back, I had this client who was scientists. They were developing transgenic technology in cotton. And they had a lot of disputes, but they would never fight. They were very nice people. But the only time they really fought was when their technology was challenged, because that was the most critical part of their business. And when they fought, that fight was a scenario where the founders were involved completely. It was like their business. So you must choose your litigation or your disputes when it really threatens your very business. So in a way, if you ask me, if you need to fight, you must fight. But if you have to fight, you must always keep a window of settlement open at all points in time. Litigation is not going to take startups and the founders anywhere if they decide to fight for the sake of fighting.
what about leveraging litigation? So in our country, interim orders become extremely critical. There is a threat of litigation, and then there's actually initiating litigation towards a strategy of settling or whatever it may be. How do you see that used? And especially as somebody who's in the arena, how would you recommend that that particular aspect should be considered?
Litigation as a measure of strategy works very well sometimes. Litigation as a threat works better when you're suing a startup, because a startup doesn't want to spend money. And there could be a scenario where an investor is suing a startup and the cost of fighting the investor may be just too much. But I think in any litigation, a strategy for litigation in a startup must be to find a way to settle. And therefore, if at all you're leveraging litigation for a purpose, then you must be clear about that purpose and how far you're willing to go with it. It is, I think, many times as startups grow to a certain level, the egos take over, and that's when a startup finds its way down. And therefore, it's critical. And therefore, since we now have Nanda, I think we can focus on him.
Welcome to Nanda as well. As I said, we have hardcore litigators. This is actually he was actually busy in some cases. So we got going, Nanda, and we were just discussing frameworks and how to think of when to go to court. Are there situations, Nanda? Let me turn to you, where we have different modes of, dispute resolution. We'll think of arbitration, mediation, litigation, but sometimes we may want to go directly to court. And court itself as a leverage strategy for a founder or for a startup. How would you think of that kind of an approach?
First of all, I'm sorry about the delay. He was right in saying that I was in fact in court, and whatever time it takes between the High Court and here, that's the amount of time I took. Very quickly, there are several reasons why not just startups, but any company might choose to go to court instead of adopting another dispute resolution mechanism. The first of these is posturing and positioning. You might want to go to court so that you get an interim order or any order, or even the fact that you filed a suit or a proceeding might demonstrate the seriousness that you have. Getting an interim order, as Dhyan often does, is something that not often for startups, though he appears only for the big MNCs. I appear for the startups. Is something that will help you in posturing if you have to get into a negotiation. So very often parties do feel that they're better off with an order in hand, with a certain sort of an advantage while going into a negotiation. Obviously, the other side would want that vacated before you go into the negotiation. So that's one other reason. The other reason that I can think of is that very many of these startups will have arbitration clauses in their agreements. And the first port of call before you initiate arbitration is very often a Section 9 proceeding where you go to court because your tribunal is not yet constituted, at least under the domestic situation. Of course, if you have a SIAC clause or whatever, and if you're second stage, third stage funded, you might have a SIAC clause where there's an emergency arbitration clause or an ICC clause or whatever else. But plain vanilla startups, very many times you do not have any of these, and you don't have an institutional arbitration mechanism. You have a simple arbitration clause, which means that, again, for the same reasons that I mentioned, you might want to go to court, try and, in some ways, get ahead of the game, get ahead of the position, and then see how it plays out.
Got it. So just a follow-on from there. When startups are thinking of their contracts and like what is the dispute resolution clause that I should be including there? What should be in that clause? Again, my MCIA friends will be very interested in what you're going to say now. Depending on who the counterparty is, many big investors may say that, hey, I want a SIAC arbitration clause. But how should founders think about whether it should be MCIA, should it be SIAC? What are these factors? How should they think of the seat of arbitration? How should they think of the governing law? Because oftentimes, startup founders they don't know the law. They are very good at one thing, which may be building a product or operating in a particular area. They oftentimes are not even looking at these things. They just want the deal. So what would your advice be to startups and lawyers who are advising startups?
Right. Because I came late, just to try and score back some brownie points, I'm going to say use the MCIA clause. But no, but jokes aside, on a very serious note, for a reason, dispute resolution clauses are called sunset clauses because very often at the end of a long negotiation, these are just inserted as boilerplate clauses. So that's something to be wary of. Having said that, I would say that typically, let's just turn it on its head and look at what are the typical disputes that startups face. First set of disputes are amongst shareholders or amongst the promoters themselves. That's a very, very common regime of disputes. The second set of disputes are between investors, or one set of investors and the company / promoters. The third typical ones are between ex-employees who started something similar. The investor is making a noise about IP, so you just go and file a bunch of proceedings and say how they are, violating your IP, took away your source code, blah, blah, blah. The fourth set is typically with vendors or whatever, but those are, I think, less frequent, and they're not unique to the startup world in that sense. My sense is that at least as far as startups are concerned, definitely you need to have a strong pre-litigation mediation clause, which will facilitate your being able to go and try and resolve this with the least level of pain. The point that you made about startup founders not being very sophisticated with their legal understanding, I think it's equally true that they simply don't have as large a professional setup under their command that they can say, all right, I'm going to ask my legal head to go and negotiate. I'm going to ask somebody else to go and negotiate, because it comes down to the startups running the whole show themselves. So in many ways, it's important that you realize that the time that you spend as a startup founder, as a promoter, as it were, is quite huge. And in order to save that time, I definitely think it's advisable for you to, as a startup or somebody advising a startup, to try and keep them out of court, out of arbitration, out of disputes to the extent that you can. So mediation or pre-dispute negotiation / mediation are great techniques, and we found them effective in many, many cases, especially with investors. So that's certainly something that you should look at. Otherwise, I think you certainly need to look at, again, institutional arbitration mechanisms, which are today probably far more robust than they were a few years ago in India. And therefore, that's something that, again, in startups should certainly look at.
Maybe there's something in it for law firms to think of in terms of catering to startups, a manual or something of the sort, a playbook in terms of how to think of these concepts. I think it'll be very useful for a lot of founders as they start up. But to shift gears a little, and Nishanth, maybe I can come to you. As I said, costs is a big thing. About a year and a half back, a founder approached me in relation to an IP matter, and I strongly urged him to go very aggressive on a litigation. And he said, no, it's not a priority, so on and so forth. A year later, they lost a case at the ITC in the US, International Trade Commission there, and a 450 million funding round got scuppered. And then he came and told me, Mohit, you were right. But the reason he didn't go ahead at that point of time was costs. So on that point, Nishanth, this is obviously a big factor. What are some of the kind of solutions available for startup founders? So one is litigation financing. There are a few firms that are providing that. Is that a thing, especially in India? Could founders think of that? The other is just some of the insurance policies, DNO, cybersecurity insurance, even litigation insurance pieces, if that is something that founders could consider. And finally, in the US, I'm aware of law firms. Of course, in India, it's not permitted, but law firms are able to take equity in companies in exchange of legal advice. The Bar Council, I know it's very far-fetched, but just it's an interesting thought exercise. Is that something that those kind of solutions should be considered?
Yeah, thanks, Mohit. Look, disputes are expensive. They're becoming more and more expensive, as days go by. And for a startup, like Mohit mentioned, each and every dollar, they need to see to it that it goes the full mile, and they're getting the best benefit out of each and every dollar they spend. So obviously, depending on the nature of the dispute, especially like Mr. Nandakumar mentioned, if it's say a dispute with one of their investors, or some big people like Mohit, or there are it's with some investor with deep pockets, and you feel you're in the right as a startup founder, but you're also at the same time struggling to ensure that you get the full representation that you should be getting in court or before an arbitral tribunal. Litigation financing is definitely a good thing to consider, but to ensure that litigation financing doesn't seem like the one solution for all problems kind of a thing. There are some inherent problems. And the biggest problem, or rather the biggest factor that will come into play is, where is your dispute, right? Because I've had conversations with several, litigation funders who are very, aggressively looking to invest. But the moment I tell them it's likely to be before Indian courts, then they take a step back and say, look, I need to do a full due diligence. Because ultimately for a litigation funder, what matters is how quickly can I recover this money the money that I am promised at the end of this litigation. And unfortunately, we have seen that even after a successful domestic arbitration, we end up seeing extensive challenges before a Section 34 court, and then you take it all the way to 37, you go to Supreme Court for an SLP. I thought it would stop there, but now 2 more layers have recently been added as well, which is review and curative. So litigation funders are a little, apprehensive coming to India. Now, say you have a foreign-seated arbitration and you have a good case. Again, some considerations are whether you're the claimant or whether you're defending it, right? If you're a claimant and a funder feels that you have a good case, then there is a good chance that you will be able to convince them for a good litigation funding arrangement. But if you're defending a case, which more often than not startup founders do, then it may not, really augur that well for you. Now that is litigation financing. Coming to insurance, like Mohit mentioned, right? D&O insurance, directors and officers liability insurance. I have personally seen it work, and it work really well. Typically we see D&O insurance being taken either, an investor has nominee directors on the board and tells the portfolio company to ensure they have D&O insurance, or at an investor level, they get D&O insurance and they try and cover all their key officers and nominee directors across the board. But just a few things to consider for a startup if you're taking D&O insurance. As we all know, insurance are based on utmost good faith, uberima fide. And the regulatory setup in India is such that you may have received a notice 3 years ago and nothing has moved forward. And then today you're going and taking D&O insurance, and you don't disclose that notice. And ultimately, when it's time to claim, you end up facing some sort of disputes with the insurer, right? So there are several key considerations to keep in mind. One is what I just mentioned. The other is generally anytime you receive a claim, or you are thinking that somebody may sue for whatever reason, or a regulatory authority may sue for whatever reason, it is a good idea to first assess whether what your position is in so far as the insurance is concerned. Look, the third thing I think, Mohit, sorry, it's a long question, so I'm taking some time. The third thing Mohit mentioned is, taking fees in the form of equity. So while I think it's definitely a good idea to start a conversation around it, I think it ultimately boils down to, especially in litigation, I think it ultimately boils down to whether, ultimately a litigating lawyer first duty is to court. And the moment you're seen as having a part or being one of the owners of your client, that may end up raising certain conflict considerations. But insofar as non-litigation work is concerned, all for it. I think, startups deserve to, pay through equity if they think that is the best way to go forward. and get legal representation for them. I think I'll stop there, Mohit. Yeah.
Yeah, I mean, we could go on and on
Yeah,
about
yeah.
that. In the US, for example, startups can be much more aggressive because they have these things. It actually fosters the growth. But we, of course, have many other hurdles to surmount before that. But changing gears a bit, and then again, I want to bring back the concept of dispute resolution modes. And I wanted to speak a bit about mediation. There was in the middle, like a few years back, a lot of talk about that. Now the focus has again gone back to just arbitrations. And how effective do you think has that been more from commercial disputes perspective? Of course, on the family side, you will have a lot of those things working very well. But from a commercial perspective, how do you think of that? And should startups actually be thinking of putting those clauses, or is it just not worth the time?
The mediation, I think, is a great way to resolve if both parties are willing to do it. The problem, of course, lies in the fact that when you get into a dispute scenario, given the fact that courts in India take their own sweet time, everyone believes that delaying dispute resolution has a lot of meaning for a party who has a bad case.
Yeah.
And therefore, mediation almost falters at that level. But I think what is, and possibly an interesting drafting technique which could be used, is to introduce a mediation clause and nominate a mediator in that clause. Because I've seen good mediators are still able to settle disputes, notwithstanding the initial resistance of one of the parties. Therefore, by putting in a good institution or a good mediator as a named mediator, you're actually able to bridge that requirement of having to find a mediator after the dispute is started. That is one way of doing it. The other is to say that if any party does not put in good faith effort to try and mediate, then there must be a liability of costs on litigation or arbitration once it is started. So these are, of course, contractual mechanisms which parties can think of, and I think law firms can introduce. Because for startups, that may actually prove to be extremely fruitful in trying to resolve or nip disputes at its bud. So I believe that that could be one way of doing it. But if you ask me quite honestly, if a party doesn't want to settle, there's nothing much you can do about it.
Right.
Sorry, Mohit, if I can comment on
please,
that. I
please.
just wanted to reiterate what Dhyan is saying. And I think I don't agree with you when said mediation, we talked about it and we're not talking about it anymore. We're still talking about it. And we've seen n number of commercial disputes resolved through mediation. I think what has happened is that law firms and lawyers have matured. I mean, when I started off, people would say, we are not going to be the first people who are going to talk about mediation. I think now we do. I mean, at least a lot of good lawyers I know do. So that conversation helps move things along. And if you can't name the mediator, there are plenty of good mediators available. And mediation at best, I mean, mediation has a success of 80% around the world. We now have the Singapore Convention for Commercial Disputes. So we have, and India has a legislation, we have moved miles. So startups should definitely look at mediation. If you can't name your mediator, there'll be ways and means around it. And mediation at best will take you 48 hours. And you may succeed in those 48 hours as opposed to the long hours of litigation. So I think it's definitely worth a try, and people should. And hopefully the startup community will tap in on that.
I think that's a great point. Maybe we'll invite you, Poornima, to take a course with our startups on how to think of this and putting those clauses. Yes, Shilpa. The next question was for you only, but please go ahead. Yes.
I mean, I fully agree with both the panelists.
Please put the mic, hold it up. No, just hold it to your mouth.
Mediation is the best way out. But like that, in practicality, what we are observing and experiencing, that we had like a few cases, because now in commercial court act, like now before the commercial this disputes initiated, like now you have to go for mediation. But like now every time we tried, and I'm very much on like settlement and mediation and amicable settlement, other party is not turning up. And
Which
they
is
say
why-
we are
which
not
is-
interested.
Which is why I think Dhyan's suggestion of
Yes,
putting this into the
cost.
contract
Cost.
and putting this into the contract itself is something that can certainly should be thought of, I think. And startups should leverage that because it will actually be the cheapest form of dispute resolution for them. Shilpa, I wanted to ask you a question. A lot of the founders in startups, their products, especially if they are consumer-facing products, they will have standard form of contracts. And typically, there's a lot of friction at the consumer level. Consumers are disgruntled. There'll be consumer commission cases, so on and so forth. So how should they think of dispute resolution in that context? Because the volume of these things can add up very quickly and can be a huge friction point for a startup or for a founder. So when they're thinking of dispute resolution in that context, what are some of the key things that you would like to see which are being included in those contracts?
Yeah, as all of us discussed, that startups are always in financial crunch, and that's why they have to depend upon the standard form contracts. So templates, what we call. So generally they depend upon that, but you can't have the standard contract for all the requirement, but majority like vendors contract, employment contract. Some amount of IP contract, it can be done. And as you ask, for clause, so I would suggest, because now consumer forums and consumer commissions, they are also taking years together. When they started, come up with this law, they thought won't take much time, and short duration they will be able to. There will, lawyers not required. Various things are there, but each and every, those consumer forum case or consumer commission case, they have the lawyer, and it goes on for years. So I would suggest, in a conciliation, maybe the first one, and two. So that should work well.
Yeah.
And that also they should go for one conciliation. Now it is there in the framework, Arbitration Conciliation Act. They have nicely, incorporated the provisions.
Right.
So I think conciliation should be the...
Right. Okay. Poornima, I'm going to turn to you now. Actually, I want to ask a little different, a different construct. A lot of startups that are especially having software products, large companies like a Facebook or an Uber or any one of these large tech companies will have product legal teams that are studying the product. Is it complying with privacy? Have the appropriate disclosures been made? Am I taking user consent? So on and so forth. How much time do you think a startup should actually invest, keeping in mind their resource constraints, in terms of this product review piece itself? And is that something for which they need to engage lawyers? But before they launch their product, basically, how much of due diligence should they be doing? Is it sector specific? Would you factor in that, there's a regulator here, or there's a privacy issue here? How should they think of this broad point?
Thanks, Mohit. I think there are different kinds of startups and different kinds of founders. You do actually have many mature founders. And most startups, if you're looking to go into a niche area, should talk to lawyers. Many law firms in the room are talking about the recent ban on real money gaming, right? Nobody expected it. And we're getting calls from people saying, we can't pay your bills overnight.
But to that point, all of those companies would have taken legal advice, and they're all shut today.
But how many of them are actually challenging that, right? Only a few. We have some cases pending before the Karnataka High Court now. But how many of them would actually think of challenging this legislation? Are you thinking about going forth and reviewing that? And is that something that's going to happen or not happen? Or where are you looking to do that? So those conversations, many of them I'm sure are not looking at, right? So I'm saying, how are you going to approach a problem? So one is what you're saying is, here's a niche product or a niche issue or a niche breakthrough, let's say, that's going to happen. And do you need protection? Of course you need protection. Maybe regulatory protection, it may be IP protection. And you must get it. And I think most startup founders are conscious of that because I think everybody believes that they have the next big idea. So that protection and conversation should be taken care in whatever way you want to do it, whether it's inter-se between founders, whether it's with investors and founders, whether it's a sort of a public law in rem remedy. And I think most people will do it. So there are different kinds of protection with each of this, and also regulatory review and where will that stand. So all of these different verticals will have to be addressed and done. Otherwise, they will have to step back and that will not be addressed. So we must encourage people to do it. And I think there are also niche associations. The Gaming Association also has, the NASCOM helps people. So depending on where you fall, you have that protection and that engagement. And startup founders are leveraging that.
All right. Yeah, please, Nanda.
I think At the heart of this is the fact that most startups don't take compliance very seriously. Legal compliance, regulatory compliance, and therefore in disputes inter se amongst founders and in disputes relating to regulatory issues like the ones that say Poornima was referring to, they run into a lot of hot water. A lot of disputes can easily be avoided if there is a greater focus on compliance. For example, they won't have their memorandum and articles of association in great shape. They won't have minutes of meetings. They won't have, a lot of things that you take for granted, they simply don't have.
But Nanda, sorry to interject. The problem is a lot of these founders and startups, they are just trying to get their product out. It's a question of survival.
You're right.
Compliance becomes a luxury. So what are some of the ways in which they can think of
I was
this?
just coming to that. I think very many times startups start thinking seriously about compliance only when they're looking at funding.
Good point.
It is true. It's
Because as investors, we will
exactly
ask for
right.
those
So investors want to make sure that everything's in apple pie order, or they think it's an apple pie order. Won't get into what you're thinking. No, so I think, therefore, this is something to pay attention to. I also think that you can actually be compliant at a very low cost. I mean, there are today techniques, there are people who do it, there are businesses that do it for you, there are, it could be a company secretary, it could be a small law firm who will help you with a lot of these things at a very, very nominal cost. And I think you have to accept that as a part of your costing in whatever product you're building or service that you're offering. And if you don't do that, I mean, it's like taking insurance in some way. And if you don't do that, the potential cost, you mentioned a $450 million deal that went a-begging. I mean, that's the sort of price that you'll pay. So my sense is that as a startup, you shouldn't wait till the point in time that an investor thrusts compliance down upon you, and you must sort of have tried to done it proactively from get-go. And that very often avoids inter-se disputes amongst promoters and founders. And I mean, very, very, very typical, you'll have 4 friends get together, start something, and then those naraha and, usual story. So that can be avoided.
Right.
Sorry, I
Poornima?
I was just going to say, not so much arbitration litigation, but the number of startups who've said, we don't have the money to set up a sexual harassment policy at the workplace. Right?
Yeah, that's not a...
Yeah, but people do say, we don't have women, we have 2 women, we don't have a senior woman. Not anybody's point to say, why don't you have enough senior women? We don't have the money to give you for a posh policy. And how many of them have had reputational risks, governance issues, all because you just didn't set up a committee, right? That is compliance. And yes, there are so many young lawyers who could have put it together for you. And that's the culture that you start building, right, of compliance at various levels. I just wanted to make
I think there's a really great case here for a playbook, which can be a plug and play, at least a low friction one for these kind of companies. But Poornima, yes.
I just wanted to add and say.
Sure.
So, I mean, we had one client, and he just sent me one mail and said that, Shilpa, just look at this. We are planning to sign this. There was a share subscription agreement, 55-page agreement. He said, just glance through, please. We are planning to sign it. When I looked at it and then sent the red line version, he called me. What is this, Shilpa? He is my friend. Like an investor, he is my friend. He's saying we were in same wing. I said, yes, but you are now in different wing. So it's totally like a different party, but like trust factor generally. Founders are, most of the time they are friends or ex-colleagues. And similarly, investor is also friend. Then you feel that it's a cakewalk, but it's not.
Some people say that a contract is ultimately, you may write whatever, the intent also matters of the parties. But Poornima, quickly, how much time do we have? I'm not sure when we started. Is somebody? 10 minutes after 5. Okay, fine. Poornima, turning to the relationships of the startup with its employees, what are some of the mistakes you're seeing? Firstly, in creating this culture of compliance with lawyers, you advise a lot of startups and companies on this. What are some of the mistakes you're seeing startups that are making, and how can they handle this, including in their employment contracts? How should they be thinking of this? Because a lot of disputes bear out with your employees, and a lot of disputes are because of employees who may have gone rogue. So what's your experience on this, and can you share some thoughts on this piece?
So I'm going to come to this in a different way. I think a lot of startups have told us that they're high stress environments. And my experience is that if any organization is under extreme stress, there are going to be disputes, right? I mean, look at startups or companies that are going through reorganization, retrenchment, whatever else. Huge amount of employment-related disputes, huge amount of discontent. So you have to plan for that. So in a startup situation, you're looking at people and culture, you'll have to look at work, growth, and compensation. So if you look at all of this commonsensically and say, either between founders, whether they're 2, 3, 5, who's going to do what? How are you going to be compensated for that? And are you looking at how these people are going to exit and what happens if you don't do what you said you would do? And put this in some even very commonsensical contract. That's going to be great. If you don't do that, then that's where the issue starts, right? And we've seen many. And often people will settle simply because there's an investor, they don't want the organization to suffer, many reasons. But if you don't have that, the time and energy going in building the organization will now be going in sort of resolving this one way or the other. It's also important to talk about IP in your contracts. You are creating it for the organization, it's not your IP. What happens to the IP in the context of an investor? Who's going to sit on the board? How are decisions going to be made? And when an investor comes in, what about exit rights? How is that all going to work out? So I think these are what are called transfer restrictions, if any, are also important aspects to consider. We do have non-compete. I think they've been tailored a little bit more for promoters or founders to say these are the people who founded it, they know more about it, so they can't walk away easily and just replicate the whole system somewhere else. But they're difficult insofar as the regular employee is concerned, but you do still find them in terms of employment contracts, but difficult to enforce.
Got it. Dhyan, I wanted to now move on to certain specific kinds of disputes. I mean, we can go on and on about this topic, but inter-se shareholder disputes is obviously a big category, and I know you have personally handled many of them, including some very high-profile ones. I mean, my firm may have been an investor in some of those. So, in relation to these disputes, when the company is doing great, everything is wonderful. You know, investors are encouraging the founder. No questions are really asked. Founders are, going ahead and doing what they want. They're given because there's a high degree of trust. But the minute things start going wrong, problems creep in. That's when people start looking at the contract for the first time, which may not even have been looked at even once. So, given this, in your experience, what are some of the most obvious pitfalls you see, which you think that, my God, I keep seeing this pattern. If they had only addressed this in the beginning, or they had taken certain steps in terms of information sharing, whatever it might be, it may not have led to this. Can you share some of your experiences on this and learnings on this piece?
Mohit, when, as you rightly said, there are 2 times founders fight. One, if the startup is doing exceedingly well, then it's a fight for control. If the startup is doing badly, then it's a fight to exit and how best to get out. And of course, one wonders why would the founder fight with the investor? Because after all, the investor is the one who funded the entire exercise. But then still there are fights with investors or investors fighting them. And I've seen on many an occasion, investors want to take over the company. And the best way to take over is to fight the founder so that the founder then exits. So you see, some of these are strategic. I mean, we're nobody to judge why they do it. But I think there are 2 things. One is, of course, a good contract. A good, fair contract is a mechanism by which you can avoid a dispute. But the problem is founders, when they start, never enter into a contract because they're doing it on good faith. They're good friends who've gotten together, they want to develop something, they want to build something big, and therefore the first time they ever look at a contract is when there's the first round of funding. And that's when an investor comes in, and they must hope that the investor is good and who'll want to stay with them for the long tenure and not look at someone who's going to want to exit at some point. As you rightly said, valuations are very important. And sometimes, and in some large startups, you saw that as valuations went up, the investors valued it even much higher. And then when it dropped, then everyone wanted to fight. And then it became a fight for really control. But I think, quite honestly, contracts are not an answer to this. No matter what you may put in a contract, the fight can still go on. And you'll see lawyers come and argue in oppression mismanagement proceedings that contracts of this kind must not be enforced. Or you must take away certain rights which are granted to certain investors because they are misusing it.
Right.
Like Nanda would certainly agree with me in many of the arguments that we've advanced against each other. Sometimes he does, sometimes I do. And you have arguments in oppression mismanagement because the contract can still not be binding on the tribunal. An argument is possible to say that this was given in certain circumstances which we never thought would exist today. And today you're misusing it for a certain benefit, and therefore your conduct is oppressive. So if you really ask me, the most important thing in all of this is the ability of the investor and the promoter to talk and to be transparent about what you're doing. I think most of the time, transparency is sufficient to give enough confidence to the investor to stay invested and enough for the promoter to know that at least he's been open about it. The problem is when you hide. The problem is when you don't disclose. And those problems are problems which are much, much larger and no contract can ever solve.
Yeah, I think you hit the nail on the head. There's so much more practical experiences we could talk about, but unfortunately we can't. But I think that's absolutely right. Transparency is critical, and being frank and forthright is extremely important.
What do you think of this, Mohit? I mean, just putting it back on you. As a
I wasn't expecting any
non-court-going lawyer.
No, but of course we are investors in companies.
There are 5 lawyers on the panel. I mean, you really can't get away with it, can you?
Well, I actually agree with what Dhyan just said. Transparency, information sharing, being candid is the most important. And speaking the truth, even as investors, when you're seeing pitfalls, just because a founder is doing well doesn't mean you don't talk about it. And having that trust is actually the most key thing. It may even result in an investment coming to zero. That's fine. But being truthful is extremely important. The big 2 kinds of fraud we see. One is the easy fraud, which is someone is stealing money. That's the bad intent. These are not complex cases. You have to sue. The tricky one is when founders get under pressure and they start cooking up the numbers in terms of showing good numbers, because they may be feeling pressure from somewhere else that they need to show it. And we'll make it up in the next quarter. That's when the problems kind of start sliding and it becomes ugly.
But can I just take 1 minute on that?
Sure.
It's not often that Dhyan and I get to say this to one another, but I completely agree with Dhyan here. We really.
I'm sure you're on the same side once in a while.
Yeah. No, but jokes aside, I think Dhyan hit the nail on the head really, and it's something I wanted to say. The other thing that I think, in addition to transparency, and I'm just going to tie in to what Mohit said, whenever there is some problem, there's somebody who's hot under the collar, the best thing is to have a discussion. I mean, you try and ventilate whatever grievance it is, thrash it out, try and talk it out and be done with it. It'll really save a lot of heartbreak and heartburn and a lot of lawyers' fees in time to come. The other thing that I wanted to say was that very often, and Mohit actually made a very nice point, there are obviously some cases where there is siphoning of funds, bad faith. I mean, clearly there's something that's not within the 4 confines of the law. There are very many cases where this sort of hiding of information with the fond hope that I will today solve the problem and next month I hope the results will be better, leads to a situation where, though you never intended to, you'll get labeled as a fraud at a later point in time, which is actually avoidable. And the minute you get labeled as a fraud, you want to fight back and say, no, I wasn't, and then you want to clear your name. And it just gets into a bit of a unnecessary tug of war and completely avoidable. So therefore, transparency and fairness and really trying to de-escalate and dispute avoidance are to me the most key factors.
Yep. Nishanth, I wanted to ask you, A very common mistake I see startups making is, in relation to the management of data and corporate records and so on and so forth. When it comes to a dispute, they know they've been wronged, but when it comes to actually showing the evidence, they're very, very sloppy. So, what are some of the pitfalls you see? The other point, actually, any one of you could chime on that, is attorney-client privilege. These are concepts they don't really grasp. These days with ChatGPT, it's phenomenal, by the way. You put in legal questions, you're getting very good answers. It's like a third-year law firm associate who is in my computer. But and startup founders will naturally use this. But what is happening is that confidentiality is not being maintained, and they are compromising themselves on privilege by asking it as if it's their own lawyer. So, these are some of the challenges. How do you think startups and founders should think of these aspects, and how critical is it actually?
Yeah. A lot of third-year associates are not very happy with you right now. But
it's the truth, though. You have to get ready.
So, on a lighter note, of course. So, a lot of things were mentioned during this discussion itself, right? Mr. Nandakumar talked about maintaining minutes of meetings, right? And I have an example to give there. I was advising a promoter who seemed to be on the right side of things, at least from the outset. And he's saying, no, this is what we had agreed on, this is what we had decided. But each time the minutes were circulated by the company secretary, as a matter of course, the investors, nominee directors always had some few subtle comments to make on those minutes of meetings. And the founder was like, you know what, it's my company secretary, it's my company. So I'm not going to really, look at this. He never made any comments. And later, many years later, when several of these things came to be questioned, or these became points of disputes, then, okay, I'm telling the promoter, look, I agree with you, but this is what was recorded in the minutes. And the minutes do not reflect your position. And that's just one example, right? So minutes of meetings is one thing. And generally, I mean, look, there can be no quarrel about the fact that you have to maintain proper records in the event of a future dispute. But usually what ends up happening, especially in the context of a startup, is there are like two top guys or two top people or three top people who are managing everything, who are looking at getting investors, who are looking at the business side, who are looking at the technical side, and a lot of other things. And the more structured sort of setups are not there to ensure you end up maintaining records the way you'd ideally like to. That obviously will have to change. And with modern technology, with a lot of these apps now coming in that don't cost the startups too much, I think it's critical. But I just want to address one other point that doesn't usually come up, and which is people leaving, right? And you have three top people, one person decides to leave or is planning to move out of the organization, but you also have an active arbitration ongoing where you need that person as the witness. That is also, the best evidence you can give of the dispute that of the transactions that took place prior to the dispute. So how do you deal with that? Startups should really think about, when a key person is exiting, having some clauses in their exit formalities that allow them to or bind them to come and depose on behalf of the startup or something like that, because we see a lot of churn generally in startups, and this is something that doesn't usually get discussed. So yeah, those are my points.
Got it. Poornima, I had a question. Nanda had touched upon a bit in terms of compliance culture. But on corporate governance, again, governance can be a luxury at an early stage. You don't have the time or the resources or the advisors to advise you. What we have done at our firm is we are trying to convince founders to have a tiered structure of governance. If you're at this much revenue, you should have so-and-so committee in place. At 100 people or whatever, 100 crores of revenue, I'm just making it up, have a CFO, an audit committee, something like that. So those checks and balances are there. Is that something which you would think is how startups should think of corporate governance, or they should go whole hog from day one when it's a survival issue? What are some of your thoughts on corporate governance for startups?
See, I think wherever the law is clear, you have to comply, right? I mean, I can say, when many founders tell us that this is a luxury, but there's a huge reputational risk. And once you're seen as a non-compliant startup or a non-compliant founder, there's also a reputational tag that comes with it. I mean, also in the larger context of this discussion, if you're going to be a litigious founder or a litigious person, that's going to come with you. People don't want you to see that. I mean, you're in the same ecosystem, you're going to speak to the same founders, the same investors. So I think if it's a law, you've got to comply with it. So there's no two ways around it. You can't hope not to get caught, or you can't hope that things will not fall in play. You have to comply. There's no other choice in that matter. But of course, the corporate governance aspects depends on the industry. I mean, are you greenwashing? Are you environmentally compliant? What's your carbon footprint? Those kind of things, the nice to haves are, I think, individualistic. You also have young startups who are very green and want things to be done in a certain way and will comply. So it depends on which industry you are, what you're doing, and where you're going. But if it's the black letter of the law, you have to comply. I don't think there's no two doubts about it, right? Corporate governance, which is, do you want more women on the board? Well, yes, I would think I would like that, but maybe some people don't think it's necessary and they would rather have somebody else and they won't look that farther away. So maybe that'll come with culture, or maybe it won't come. So, and that's something that nobody can really push people to do.
Yeah. No, we can always see red flags coming up. Is a company making like PF deposits on time? Even if you check some common filings, you can see those things. Like we now have begun to see a pattern, which we can spot early, and we get investors to then talk to the founders. But on this theme, and I want to leave some time for questions as well. Shilpa, I'll leave you with the last word on this. Like from your experience, can you share a practice, a ritual, a quarterly ritual, or something which you have seen companies at early stage can follow, which would prevent disputes? Because I think, including the senior councils, everyone is agreed that you're better off not fighting. I think that's a fairly obvious conclusion. So I thought we could end with that, at least from the panel.
Yeah, so I mean, for ritual, you can just only do for like a quarter ritual. So only can do for regulatory compliance, like to see that house is in place and there are no issue. But so far as other things, as and when required, they have to take help of legal mind, which generally founders, startup, they avoid and then they fall in the difficulty. But they should take help of legal mind, so to avoid those disputes. And all the contracts should be with clarity and in unambiguous manner.
Okay. All right. Big thank you to everyone. But before we wrap up, we can open it up for a few questions. Neeti, I think I was on time. We were on time rather. But okay. There's a question. Can someone hand over a mic? Or?
I think Poornima touched on it briefly when she mentioned one of the reasons that founders may be adverse to litigate is because they don't want to be seen as a litigious founder, right? So I just wanted to know your opinion, Mohit, and also the rest of the panel, Mohit's opinion, of course, being on one of the big investors, and the rest of the panel on both sides of the forum. But do you really see perception or the risk of being seen as if a litigious founder or a trigger-happy investor, do you see that as an effective deterrent from taking up disputes, whether it's in court or even mediation and arbitration?
Yeah, I think the best founders would actually not care about the optics so much. I'm just telling you, I'm not saying this is my view. I'm telling you what I see from founders. The best founders will just do what is right for their company. And if that means that they have to litigate, they will litigate. I worked with the founder of Uber for the longest time. He had a tenacious reputation. Everyone knows he's going to fight. No matter what, he will fight every government. And that was a reputation. With it comes certain costs, because they will think you're brash, they will think you're aggressive. But ultimately, that was the approach that worked for the company and made it a very successful company. There are other founders who will be very averse to litigation, and they will just not want to fight. So it will also depend on the industry. So if you take a company in the fintech space, they should be more conservative. They should be more measured in their approach. They should be very forthcoming with regulators, engage proactively with regulators. But on the other hand, you may have a company that's operating in a new segment, like, online gaming. Of course, ironically, a lot of them are not taking up the challenge. But they should expect that they will have to litigate at some point of time, because they're going to face a lot of, or Uber, where you were up against the transport regulators everywhere who are banning you. You don't have a choice but to litigate. So it will depend on the industry, but it will also depend a lot on the personality of the founder. And most founders will do what is right for their company. And that's what I see amongst the best founders. They won't care about the optics. They will do what is right for their business. I don't know if there are any other thoughts on this.
I just wanted to very quickly add that invariably, whether you're a founder or not, invariably, there are typically 2 or 3 reasons why somebody goes into litigation. One is that you have a certain goal. Second is that you very, very firmly believe in, that this is the right thing to do and matter of principle and so on and so forth. But ultimately, what it comes down to is that everybody does a cost-benefit analysis. And it's only after that you either start the litigation or get into the settlement or continue with the litigation. Very often, what starts as a point of principle, you run out of, and then you realize your legal costs are going up quite significantly. And then you're not too sure that you want to, that the principle is as important as it seemed like a year ago. So these are questions also that possibly a startup founder has to look at more closely, in addition to what, of course, Mohit pointed out.
Yeah, I think there's one more question here. Someone. And there was one there as well. We'll get to you. I've seen your hand.
Hi.
Yeah.
So we have spoken about, disputes between investors and founders and all of it. But there's a very big component that is defamation and publicity, negative publicity. So what is your view on that? Because there are multiple online magazines and platforms which have said in the past, and there are multiple litigations which are going on for years, especially for startup founders with respect to whether it's about counterfeiting or on those lines. So what is your view on that?
I'm let Dhyan take that.
Well, if it's the truth, better to keep quiet. But if it is...
Truth is a defense. It's a defense as well.
So it's better to keep quiet. But if it isn't, then of course you must fight. There's no question. And in a fight of that kind, there is, I think, very difficult to really settle. You take it the whole hog. You make it appear to everyone that you are the one who's standing for what is right. And I think if you don't do it, it also indicates to everyone else that possibly there's some truth behind what is written online. So I personally always advise people, if you find something defamatory and you're certain that it's not the truth, then you must necessarily fight.
But then what about, so there's something called the Streisand effect. Barbara Streisand was this Hollywood personality, and there was some article written about her, about some construction she was doing for her personal home, and nobody knew about it. But she filed a defamation lawsuit, and now suddenly everybody knew about it. So this lawsuit itself resulted in more people knowing about it. So sometimes it may be untrue, but if it's a small publication, would you still think it's worth going?
Yeah, see, if it's something, you're absolutely right. What happens is, once you raise it, everything opens up. And if someone calls you a fraud and you want to fight it, when you do go into trial of a dispute of that kind, they can raise anything under the sun to show you're a fraud. And therefore, of course, there's no question, it opens up a huge Pandora's box. But which, as I said earlier, it's really like choosing your battles. If it's something which is very elementary, very fundamental to your existence, then you must fight it. Yeah. If it's someone who's irrelevant, suppose it comes up on the front page of Times of India and it's false, then you must fight it. But if it comes in a classified somewhere, you might as well ignore it. There's no point in fighting it.
Yeah.
Just a follow-up question, sorry. It's to you, Mohit. As an investor, what would be your take to, say, one of your founders having a piece written on them which is bad for business? As an investor, would you encourage them to fight, even knowing that it might open a Pandora's box?
It's what Dhyan said. It depends. You'll have to make an assessment. If it's true, obviously keep quiet, move on. If it's not, and if it's on your reputation, if somebody's calling you, if somebody's saying you're not performing well, I would say ignore it. But if somebody's making a point to your integrity, I think that is irreparable. You must fight it. So if somebody's calling you a fraud and it's not true, or somebody's saying you stole something, it's not true, somebody's saying you hid information, it's not true, you should. But if somebody's saying you're a hopeless founder, your product is terrible, I mean, defamation may not lie, but I think those ones you should just ignore because, barking dogs, so on and so forth.
Yeah, just one small point to add there. I think it also depends a lot on where you are from an investor's perspective or the investment's perspective. Say you are preparing for an IPO, or there is some round that is coming, especially an IPO, right? And there are these 2, 3, 4 articles that you're carefully curating your profile, and then these articles are coming in about how you did this or how you're not a good founder. Maybe that could also be one of the considerations. But yeah, fully agree with Mohit.
Yeah, we'll take one last question, I think, and then we'll be on time. At time, sorry.
Thank you. Good afternoon, panel. So my question was regarding the initial part of the discussion where Mohit had asked Nishanth regarding the fundings of how startups and founders are funding the litigation or the dispute resolution process. But in my readings of what I have seen with this issue, there is a simple solution, that is the third-party funding, where a third party funds the litigation process and keeps a share of the compensation that comes. So question number one, in the panel's experience, how does a third-party funding actually unfold in real life? And number two, why has this concept or ideology not developed in India? Because in Maharashtra, in the Bombay High Court and the Madhya Pradesh High Court, we've clearly seen judgments in favor of third-party fundings, and this clearly is a solution for the issue. So why has this not developed in India?
So we addressed this when we spoke of litigation financing. You're calling third-party funding. It's the same concept, but go ahead.
Yeah, I think I briefly alluded to it earlier as well. While third-party funding is allowed in India, there's nobody stopping you from doing it. The funders themselves are a little apprehensive if it's a court litigation in India or if it's an arbitration seated in India, because they're ultimately looking at what returns they're going to get, and most importantly, when are they going to get that returns. And because of certain pendency issues and legacy issues in India, that is a problem. But nobody's stopping. It's if a third party funder is willing to fund a startup, I would say totally go for it.
I think you're going to see it more in arbitrations rather than full-fledged court disputes to start off because of the uncertainty and timing. Arbitrations are more kind of certain and faster. And I think I would say watch the space. There are going to be companies that are coming up which will offer these solutions. And I think that's good for the entire ecosystem.
But I think I just want to add that it hasn't moved as fast as we thought it would.
Yes.
Simply because it's a business for them, right? So if they're going to put in $100,000, they want to know by when can I get my $100,000 plus interest or whatever the cost of that back. Now, if there's no clarity on that horizon, or people are going to say it's going to take 20 years, that same 100,000 can be put somewhere else in Singapore or Dubai, and you're going to get your returns. Right? So it's just a business decision as far as they are concerned. They're not going to be really pushing some founder or some litigation because of the joy or the integrity of that founder. It's purely a business decision. There's a better business opportunity somewhere else rather than Indian courts right now.
So I think we are right on time.
Just one more question.
Can we take one more question? Well, I have been told. Okay. So a very big thank you to all my panelists. Thank you very much. This was a fun session, at least for us, and happy to carry on the discussion also.